Unlocking the Digital Personal Data Protection Act, DPDP a comprehensive guide. Introduction. Welcome the Digital Personal Data Protection Act, effective January 2025, marks a transformative shift in India's data protection landscape. With the release of the draft rules, organization and stakeholders now who have a comprehensive framework outlining key implementation phase, regulatory requirements, compliance obligations. Today, we explore the critical elements of these draft rules and their significance for data protection and privacy. The draft versions of the DPDP rules 2025 is now available for the public consultations till date 18th February 2025. Objections or suggestions can be submitted on official website https double backslash mygov.in. These rules have been prepared after consulting with various key stakeholders are intended to make the DPDPA operational upon publications. These rules come into force upon publication after consultations, except the rules 3 to 15, 21, and 22, which will be the effective from the latter date. The MeitY, the Ministry of the Electronics and Information Technology, official websites, https colon double backslash www.meity.gov.in has given stakeholders a 45-day time frame to review and submit their consultations to the ministry. Overview. Key implementation phases. Let us begin with an overview of the key implementation phases. The rules are divided into two phases, preliminary and operational phases, which are crucial for setting up of the data protection board and ensuring compliance. Rule first, key implementation phases. Starting with the rule first, the preliminary phase include definitions, interpretations, scope, and applicability. These aspects lay the foundations for the operational rules which will take immediate effect upon publications in the official gazettes. Setting up the data protection board rules first and 2 and rules 16 to 20. Rule first 2, a preliminary a definition and interpretations establishes scope and applicability, outlines effective dates and timelines, operational rules, rules 3 to 15 and rules 21 and 22. Immediate effect upon the publications in the official gazettes. No timeline has been specified in the draft rules. Rule 3. Notices to data principles. Rule 3 focuses on notices to data principles. These notices must be easily understandable, independent of the other informations provided by the data fiduciary and written in a clear and plain language. Detailed information about the processing of personal data and communications links for exercising rights or withdrawing consent are also essential. A presentation easily understandable, independent from any other information given by the data fiduciary, clear and plain English language, fair account of processing details, atomized descriptions of the personal data, a specific purpose of the processing, descriptions of the goods and services enabled by such processing, information to the data principals at the P, communications link through which the data principals may access their websites or the app, descriptions of any other means through which data principals may withdraw their concerns, exercise rights under the Act, make compliance to the Data Protection Board (DPB), overview of defined timelines. Understanding the defined timeline is crucial. Key points include immediate notification of the personal data breaches, detailed breach reports within the 72 hours, and various retention periods of the data breach, logs, and personal data. First, immediate without delay. Data fiduciary, data protection board, DPBB, and data principal, DP. Intimation of personal data breach. Second, 72 hours from becoming aware. Data fiduciary, data protection board, DPBB. Granular details of personal data breach. Third, 1 year data fiduciary, retention of data breach logs. Fourth, 3 years of inactivity from data principal, data fiduciary, e-commerce, gaming, social media, erasure of personal data, 48 hours. 5. 7 years since consent taken, consent manager, maintain consent records. Rule 4. Consent managers or the CMs must register a data protection board, DPB. They need to demonstrate technical, operational, and financial capacity alongside sound financial conditions and sufficient business volume. Consent managers, conditions of registration. Rule 4. Read with Part A of the first schedule. Data Protection Board (DPB) powers. Consent manager CMs must register with the Data Protection Board (DPBB). Data Protection Board (DPBB) has the power register reject applications for consent manager CMs. Registered consent manager CMs particulars and reasons for rejecting applications must be published. Company eligibility requirements. Consent manager CM must be company incorporated in India. Sufficient capacity, technical, operational, and financial capacity to fulfill its obligation as a consent manager CM. Sound financial condition. Net worth of the applicant is less than 2 crore rupees. Adequate volume of business, capital structures, and earning prospects. Rule 5. Processing of personal data by the government. The government and its instrumentalities can process of the data of data principals to issue subsidies, license, certificates, services, and permits, all under the law and using the public funds. A state and any of the instrumentalities may process of the data of a data principals DP to issue any subsidy, benefits, certificate, service, license or permit under the policy, under the law, depicted by the green check marks using the public funds. What is green check marks? The green check marks under the Digital Personal Data Protection Act 2025 indicates that the organizations or an entity is compliant with the data protection requirements outlined in the Act. This means that the entity has successfully met the necessary standards for processing, storing, and protecting personal data as per as the guidelines of the DPDP 2025. Rule 6. Reasonable security safeguards. Data fiduciaries, including their processors, must implement appropriate data security measures. These includes access controls, log monitoring, confidentiality, maintenance, unauthorized access, detections, and remediation measures to prevent safeguards. Data fiduciaries, including data processors, at the minimum should have appropriate data security and data protections measures, access control, log monitoring and reviews, maintaining confidentiality, integrity, and availability of information, detection and investigation of unauthorized access. Similar obligations of for data processors through contractual obligations, remediation to prevent recurrence, data backups and recovery, a data breach log retention for 1 year unless otherwise required, appropriate technical and organizational measures. Rule 7. Data breach information. In the event of the data breach, data fiduciaries must inform data principals without delay, providing a clear descriptions of the data breach, its consequences, and mitigations measures. Additionally, they must report the breach to the data protection DPB with the detailed information within 72 hours. Rule 7.1 Data breach intimations to data principals on becoming aware of any personal data breach. Data fiduciaries shall without delay inform data principals in a clear, concise, and plain manner. Descriptions of the breach consequences, mitigations measures, safety measures for data principal, business contact of individuals responsible for queries. Data Protection Board DPB Rule 7.2 Data breach intimation to on becoming aware of any personal data breach, data fiduciary shall without delay intimate a description of the breach and likely impact within 72 hours or more if allowed by the board provide detailed descriptions of the breach, facts leading to the event, proposed or implemented mitigations measures, investigations finding, remedial measures, data principal intimation report. Rule 8 Data retention. Personal data must be erased if it is no longer needed for the specified purpose. For entities like e-commerce and social media platforms, this period is defined as up to 3 years from the last interaction or enforcement of rules. Data retentions for specified purpose to be deemed as no longer being served. Personal data must be erased if the data principal DP does not engage with the data fiduciary DF within the specified time outlined in Schedule 3rd classes of the data fiduciaries purposes, except retention required for legal compliance or a continued account access. Entities covered e-commerce platforms, social media platforms, online gaming intermediaries, retention allowed up to 3 years from the last interactions or enforcements of rules, whichever is later. Notification to a data principal at least 48 hours, notice before erasure, allowing login or contact with the fiduciary to preserve data. Rule 10, age verification and parental consent. Data fiduciaries must ensure variable consent from parents before processing children's personal data. Due diligence includes confirming the parent's identity and age using available details or voluntary provisions through trusted means. Due, di- due diligence Due diligence under the Digital Personal Data Protection Act 2023 involves through measures by data fiduciaries to ensure compliance, including first, verifying the identity and age of individuals, especially for children and parents with disabilities. Second, obtaining variable parent consent for processing children's data. Third, conducting annual data protection impact assessments, audits for significant data fiduciaries. Fourth, conducting individuals identifying as parents or adults using reliable identification methods. Due diligence ensures a robust verification process and high data standards of data protection to uphold privacy rights. Use of the identity and the age details of the parent already available with the data fiduciary. Voluntary provisions of details by the parent through the virtual lock tokens or a digital locker service providers or entities interested by the law or the government. Rule 11. Exceptions. There are certain exceptions under the Rule 11, particularly for processings by the clinical establishments, healthcare and educational institutions, and for legal functions in the interest of the child. These exceptions ensure essential services can continue without disruption. Rule 11 Exceptions. Rule 11 and Schedule 4 Part A and B Sections 9 by 1 Verifiable parental concerns and 9 by 3 Tracking and behavioral monitoring shall not apply. Part A Processing by clinical establishments, healthcare and education institutions, and daycare centers. Part B where processing is for performing legal functions duties in the interest of the child, providing subsidies and the benefits, communication through the email, preventing accessibility of information detrimental of the child's well-being, observance of the due diligence under Rule 10. Rule 12. Significant data fiduciaries, additional obligations. Significant data fiduciaries have additional obligations, including annual data protection impact assessments, audits, and algorithmic software. Due diligence reports to be shared by the Data Protection Board. Personal data and traffic data specified by the central government must not be transferred outside of the India. Rule 13 Rights of the Data Principals DP Data principals have the right to access their data withdraw concerns, and raise grievances. Data fiduciaries and consent managers must publish details on how these rights can be exercised and implement a robust grievances redressal system. Fiduciaries and the concerned managers are to publish details of means through which rights are to be exercised, implement grievances, redressal system, define timelines for responding to grievances. Data principals can nominate one or more individuals according to terms of service of fiduciary. Rule 14. Processing outside India. Personal data processing related with the data principles within the Indian territory, whether conducted inside or outside the country, will be subject to restrictions by the central government or making such a data available to foreign states. Rule 15. Research and statistical process exemptions. Processing of personal data for research, archiving, or statistical purposes exempted, provided it meets the standard sets under Schedule 2 and does not lead to decisions making affecting a specific data principle. Exemptions for research, archiving, statistical purposes. Such a processing is exempted subject to standards under Schedule 2 and subject to Section 17 by 2B of the DPDP Act. Personal data cannot be used to make any decisions specific to a data principle. Rule 16-21 Data Protection Board establishments and appeals. The establishments of the Data Protection Board (DPB) includes appointing a chairpersons and the members, defining their terms of service, and setting procedure for meeting. The board will function as a digital office with appeal fees aligned with the Telecom Regulatory Authority of India (TRAI). The Data Protection Board (DPB) establishment and procedural aspects of the Data Protection Board are detailed as follows. Appointment of the chairpersons of Data Protection Board and other members, salary, allowances, and other terms and condition of services of Data Protection Board members, procedures for meeting of the Protection Board, functioning of the board as a digital office, terms of appointment of service of Data Protection Board officers and employees. Fee associated with the filing. Apple is aligned with the norms to set by the Telecom Regulatory Authority of India (TRAI). The Telecom Disputes Settlements and Appellate Tribunal (TDSAT) to also function as a digital office. Rule 22. Informations request by the government. Uh, Lastly, the central government can require a data fiduciary or intermediary to furnish information for state purposes, fulfilling legal obligations, or accessing a significant data fiduciaries (SDFs). Calling for information from data fiduciary or intermediary, the central government may require any data fiduciary or intermediary to furnish information for use by the states in the interest of sovereignty and integrity of the India or security of the state, or used by the state in performance of any functions under any law, for use by the state for disclosure to fulfill any obligation, carrying out assessment for notifying significant data fiduciaries SDFs. Conclusion. That concludes our detailed overview of the draft rules under the Digital Personal Data Protection Act 2025. These rules mark a pivotal steps towards a stronger data protection and privacy in India. Stay informed and compliant to navigate this evolving regulatory landscape effectively. Thank you for watching this video and don't forget to subscribe my YouTube channel Privacy Prodigy. Part A of the first schedule, consent managers, condition of registration, re- avoiding conflict of interest. Consent manager must adhere to stringent standard to avoid conflict of interest. The leadership of consent manager must have the proven record of fairness and integrity. Additionally, the Article of Association and Memorandum of Association MOA should specify measures to avoid conflict of interest with the data fiduciaries. Consent manager leadership must have the proven record of fairness and integrity. Consent managers, EOA and MOA must specify measures to avoid conflict of interest with data fiduciary. Technical criteria. Consent managers needs independent certification to prove that they have an inoperable platform for data principals to give, withdraw, review, and manage consent. The platform must align with data protection standards and assurance frameworks published by the Data Protection Board, and the appropriate technical organizational measures should be in place to ensure adherence to these standards. Independently certified, the consent manager has an interoperable platform for data principals to give, withdraw, review, and manage consent. Platform is consistent with such a data protection standards and assurance frameworks to be published by the Data Protection Board. Appropriate technical and organizational measures are in place to ensure adherence to standards and frameworks. Part B. Consent Managers Data Protection Board Focus Obligation Schedule First. Consent managers have several data protection board focus obligations. These includes first, registrations with the data protection board. Second, avoiding conflicts of interest with data fiduciaries. Third, transparent publication of leadership and audits. Fourth, furnishing information to the data protection board when directed. 5. Submitting audit reports to the data protection board. 6. Prohibiting the transfer of company control by sale or merger without the data protection board approval. 7. Prohibiting subcontracting or assigning the performance of any obligations. 8. Taking reasonable security safeguards to prevent personal data breaches. Consents managers, data principals, focus obligations, Part B, Schedule First. Consent managers also have obligations towards data principals, including first, enabling data principals to give consent through a website or app. Second, onboarding data fiduciaries to the platform. Third, ensuring data blind sharing. Fourth, maintaining records of consents, notices, and standard and share data with transfer data fiduciaries for 7 years or more. 5. Providing data principals with access to the records upon request. 6. Ensuring reasonable security safeguards to prevent personal data breaches. Processing of personal data by government. Applicable standard schedule second. When it comes to the processing of personal data by the government, certain standard must be the made. These include purpose limitations and use limitation, a lawful processing of data, insurance, ensuring a data accuracy, retaining data only as long as required, implementing reasonable security safeguards to prevent personal data breaches, providing business contact information of the point of the contact, offering a communication link where data principals may exercise their rights. A conclusion. These conditions and standards highlight the importance of robust data protection measures in today's digital landscape. Consent manager and government bodies must comply with these regulations to ensure the privacy and security of personal data. Thank you for joining us today. Stay informed and stay compliant. Thank you. Key components and requirements, consent management. In this segment, we will discuss the key components and requirements of for consent management under the Digital Personal Data Protection Act. Organization must implement transparent consent mechanisms that include clear standalone notices, detailed data processing purposes, specific information about data uses and intended outcomes, accessible consent withdrawal procedures, and integration with authorized consent managers. Security and data protection measures. Organizations are required to establish robust security frameworks. These include the implementation of encryption protocols, data obfuscations techniques, virtual token mapping system, strict access control mechanisms, and contractual safeguards between data fiduciaries and processors to ensure data protection. Breach notification protocol. A stringent breach reporting system is essential. Organization must immediately notify affected individuals and the Data Protection Board of any breaches. A detailed incident report must be submitted within 72 hours. I again repeat, note down. Detailed incident reports must be submitted within 72 hours, and comprehensive documentations of the breach impact and content measures should be maintained. Special provisions for children's data. The rules introduce specific protections for minors. This includes mandatory parental consent verification systems, flexible implementation options for verification mechanisms, exemptions for essential service providers and educational institutions, and risk-based approaches to age verification and behavioral monitoring. Schedules overview. Let us take a quick overview of the schedules outlined in the DPDP. First schedule, consent manager requirement, technical specifications, operational guidelines. Second schedule, government processing requirements, procedural safeguards, documentation needs. Third schedule, data retention specifications, sector specific requirements, threshold criteria. Fourth schedule, children's data protection, verification mechanisms, exception criteria. Implications for organizations, immediate actions required. Organization must take immediate actions to comply with the DPDPA. These actions includes reviewing and updating existing data processing practices, implementing new concern management systems, enhancing security measures, developing breach response protocols, establishing age verification mechanisms, and reviewing and updating data retention policies. Required. First, review and update existing data processing practices. Second, implement new consent management systems. Third, enhance security measures. Fourth, develop breach response protocols. 5. Establish age verification mechanisms. 6. Review and update data retention policies. Long-term considerations. For long-term compliance, organizations should focus on developing comprehensive compliance frameworks, investing in a technological infrastructure, training and capacity building, conducting regular audits and assessments, and continuously monitoring regulatory updates. A significant data fiduciaries SDFs requirements. A significant data fiduciaries SDFs have additional requirements such as conducting annual data protection impact assessments, regular audits every 12 months, algorithmic software verification, enhanced reporting obligations, and specific data localizations requirements. Appeals and grievance redressal. The DPDPA includes a digital appeal filing system with the fee structures and waivers, natural justice principles, evidence submission procedures, and examination powers to ensure fair grievance redressal. Appeals and grievance redressal. First, right to grievance redressal. Data principals have the right to access a effective grievance redressal mechanism provided by data fiduciaries, entities processing personal data. Second, data fiduciaries obligations. Data fiduciaries are must establish a mechanism to address grievance and enable data principals to exercise their rights. Third, Data Protection Board of India, DPBI. The DPBI, comprising government appointed experts, oversees grievances redressal and dispute resolution. Fourth, complaint process. Data principals can file complaints with the DPBI regarding data breaches and non-performance of obligations by data fiduciaries. 5. Binding directions. The DPBI can issue binding directions to data fiduciaries or to comply with. Thank you. In conclusion, the DPDP is a draft rules provide a robust framework for safeguarding personal data and upholding individual privacy. Organizations must prioritize immediate actions, including updating data processing practices, enhancing security measures, and establishing a robust compliance system. Long-term investment in technology, training, and infrastructures will be essential to meet these regulatory obligations. The journey towards data protection compliance requires a collaborative effort, ensuring India's position as a global leader in data privacy and security. Thank you for watching this video and don't forget to subscribe my YouTube channel Privacy Pro BG. Thank you.